So Hans Corell, let me start with you. From your vantage point as a former Undersecretary General for Legal Affairs, I'm curious to hear your thoughts on some of the primary legal and ethical issues for the United Nations with regard to harm or alleged harm done by the representatives. What kinds of mechanisms have been in place to address those kinds of issues? What ways does the United Nations think about, try to prevent, respond to, in kind of the largest sense, the issues of potential harm by its representatives?
Thank you very much. It's a pleasure to be here. First of all, may I start by saying that the rule of law, for me, has become the most important element in my thinking for the future. If you look at the world and find a conflict somewhere, the root causes are the same. No rule of law, no democracy. That is the recipe for a conflict. And for the United Nations, it's extremely important to apply the rule of law. The first element here is the members, are the members. The members of the organization must demonstrate that they follow the Charter. The UN Charter does not mention the rule of law, but when I read it, it permeates the UN Charter. And when you come to the Universal Declaration of Human Rights, adopted 2 years after, in 1948 rather, on the 10th of December, you will find in the preamble a very famous reference to the rule of law. So to me, this has been a lodestar, in particular since I had the privilege of serving on the bench in my country for 10 years before my career shifted into other areas. When we look at the UN itself, the organization, it's important to analyze who you talk about when you talk about representatives. Who is a representative of the United Nations? That depends, in a sense, on the organ that is active in a particular situation. It could be the General Assembly, it could be the Security Council, it could be the Secretariat, and it could be a peacekeeping operation, which is a distinct element here, and I'll come to that. If you look at the Secretariat, there is, of course, and certainly Kofi Annan was very keen on this, I can tell you that. He's not a lawyer, but he has a very, very deep understanding of the meaning of the rule of law and how important it is. And the initiatives he took during his tenure, they will go down in history, I can assure you that. When you look at a particular case, you have to distinguish between, first of all, whether it is a criminal act, where responsibility can come into picture, or whether it's some other act, for example, a contract which is broken, and you have to honor that in some way. But within the UN, when you read the papers that have been circulated for this panel, you get the impression that the UN has the right to investigate and prosecute crimes within the organization. This is not so. And also that the UN has a court that can adjudicate disputes between third parties in the UN itself. This is not so. There is a court, or there are actually two courts, one first instance and one appellate court, for cases between the staff and the organization. Like, for example, a dispute over the contract, or whether a staff member has been disciplined and appeals against that decision before this court. But if you come to a criminal act, or if you come to a case where a staff member has acted in a manner that a contract is violated, the UN itself has no institution to deal with this. What the UN can do is to investigate the subject matter, and here we have the Office of the Inspector General, OIOS, that can investigate. And during my tenure, there was a very close cooperation between this office and the Office of Legal Affairs. So my lawyers often assisted the Inspector General when there was an investigation. But if this investigation leads to the conclusion that a staff member has committed a crime, then that matter has to be handed over to a national court that can deal with the subject matter. And also UN staff members have immunity, so this means that the Secretary General has to waive this immunity before somebody can be prosecuted. In reality, it is not the Secretary General in person who waives the immunity. Basically, it is the legal counsel who waives the immunity. And I, frankly speaking, can't recall that during my 10 years, between 94 and 2004, when I received a request for waiver of immunity, which was an organized request and well-founded, that the UN refused to waive the immunity. Not at all. On the contrary, we are concerned that those who commit crimes, for example, are prosecuted. But then we have the very complex question of the peacekeeping operations. And here, you can't say that these are representatives of the United Nations. They are acting in a peacekeeping operation, but they don't represent the UN in a legal sense. But of course, to the general public, these will seem as UN representatives. But here, there is a distinction, whether they are military or civilians. If they are military personnel in blue helmets, they are actually still under the jurisdiction of the sending state. So the state will not denounce or renounce its jurisdiction or its own soldiers. And this is the dilemma, because if a blue helmet commits a crime, let us say somewhere in Africa, and I remember the report sometimes, and I can see Kofi Annan wincing when there were reports that they haven't behaved the way they should. That matter has to be brought to the courts in the state that has contributed this particular blue helmet. If it's a civilian, this person falls under the jurisdiction of the courts in the receiving state. But of course, there, if there is a peacekeeping operation, probably the courts in such countries are not well functioning, so there is a dilemma there. But the UN herself does not have the jurisdiction, because we don't have a criminal court, we don't have the civil court that can deal with these kind of matters. Here again, finally, before we should only make some brief comments as an introduction, there is work being done in the Sixth Committee, the Legal Committee of the General Assembly, because the situation is not satisfactory as it is, because there are jurisdictional rules also. In some states, the courts will not have jurisdiction over crimes that have been committed outside the territory of that particular state. In that situation, we have the dilemma that a blue helmet may not be answerable before any courts, because his sending state does not have jurisdiction of the case, and the receiving state does not, because of the agreement between the UN and the sending state. Here, something simply must be done. We cannot allow that crimes committed by peacekeepers are not being addressed properly before courts. So that's very important. I think by way of introduction, then of course I'm happy to receive questions. Thank you.
Great, thank you very much for that excellent start and overview.